arbitration. It's a formal method of alternate dispute resolution. Our arbitrator, similar to our mediator, it's a neutral third party or panel of experts. Generally, when I've seen arbitration, it's usually a panel of three. Okay, so we have these three guys and young lady, and they're all acting as the arbitration panel. Generally, one arbitrator is selected by one party, another arbitrator is selected by the other party, and then they agree on the third. Like in mediation, the arbitrator's decision can be binding. In fact, it generally is. The Federal Arbitration Act does not establish a set arbitration procedure. So again, we don't have the Federal Rules of Evidence or the Federal Rules of Civil Procedure. They don't matter. But the parties may agree to have arbitrator's decisions to be confirmed by the Federal District Court, meaning that, hey, we have the decision, but it has to be confirmed by the courts. State arbitration statutes. Okay, virtually all states follow the federal approach to voluntary arbitration. Okay, arbitration is fairly popular. People like to use it. It frees up the court system a little bit, and for the most part, it generally works. All right, how does it work? What's the process? Submission. The act of referring a dispute to an arbitrator identifies the parties. Most states require that an agreement to submit a dispute to arbitration must be in writing. So first thing we do is we have BM and Leonardo, and they make a submission. We want to have this go before arbitration. The next step is the hearing, in which the evidence and arguments are presented to the arbitrator, aka He-Man and his friends. All right. Parties must state the issues that will be submitted and the powers the arbitrator will exercise. Again, so these are procedures that they agree upon. Restrictions on the kind of evidence and the manner in which it is presented may be less rigid in arbitration, meaning they don't follow the Federal Rules of Evidence. Parties present opening statements, just like in court. Evidence is presented, and then we hear closing arguments. So the procedure in and of itself is similar to litigation, but it's not quite as formal. Right? The award. Right? So after all the evidence is presented, the award is the final decision of the arbitrator, and it need not be money. Okay? It just, what's their decision? How are we going to resolve this dispute? So remember, generally this is going to be legally binding. What the arbitrator says, He-Man, that's going to be the decision of the arbitration panel. Right? Enforcement of these agreements. How do we enforce it? And people always ask me, how do you enforce anything? You just do. You garnish people's wages, you hold people in contempt, whatever. But let's look at this. Look at the contract to see what the parties have bound themselves to. So if we have a contract dispute and we put this to arbitration, and just FYI, generally most contracts will have a mandatory arbitration clause, meaning that they have to go to arbitration before they can litigate. But we'll look and see, what do they contract for? And as long as whatever's in that contract is abided by in arbitration, it's still good. The issue of arbitrationability. One party will have to file suit to compel arbitration. So here we are, we got Peter Beckman, BM, Bill Murray, whatever you want to call him, and he wants to go to arbitration. Contract says that there's mandatory arbitration. Well, Leonardo doesn't want to. So guess what? We have to have a lawsuit. Oh my gosh. Alright, so BM is going to have to file suit against Leonardo to say, hey, we're going to have arbitration. Okay, so the court will decide that, send it to arbitration. There they go. Alright, the agreement to arbitrate must be explicit. Alright, and generally, whenever you read contracts, you'll see that mandatory arbitration clause. Arbitration agreement can limit the types of disputes that the parties agree to arbitrate. Obviously, what you'll find is whenever you're dealing with contracts, as long as it's agreed upon and it's not illegal, it's a contract. All right, mandatory arbitration in the employment context. Courts have held that mandatory arbitration agreements in employment contracts are generally enforceable. Yeah. Okay. Setting aside the arbitration award. Finding fact and legal conclusions. Generally, the findings of the arbitrator are binding. Right? That's our panel over here. He-Man, Whiplash, and Beach Bunny, whoever that is. I found that in Brianna's room. All right. The parties have freely contracted to the arbitration in their contract. As such, the parties should be bound by the terms of that contract. Okay? It's really, once we get into contracts, this will make more and more sense. Public policy and illegality. No award will be enforced if it result in the commission of a crime or would conflict with some greater social policy mandated by statute. All right, so check this out. You and I enter into a purchase and sale agreement for drugs. I'm in breach, okay? And you decide that we're going to go to arbitration because I failed to provide you with your drugs. Yeah, I hope you're laughing now. I mean, obviously, an award is not going to be given in this particular case because all it's going to do is further an illegal activity, okay? Defects in arbitration. There's a whole list of them on page 75 in the textbook. And for those of y'all that have had me before, you know I like lists. Okay? A waiver. Sometimes a party forfeits the right to challenge an award by failing to object to the defect in a timely manner. When this occurs, they have waived that right. All right? Well, let's talk about conflicts of law and choice of law. Obviously, there will be conflicts of law. If you're in different states and whatnot, generally they will have to look at the contract to make those decisions. And then choice of law is what state's law will the parties adhere to. But disadvantages of arbitration. They can be unpredictable. Remember, we're not dealing with judges here. They're generally experts, and they're picked by the parties. Can be as expensive as litigation. Okay? And discovery is generally not available. And that's where you go through the process of trying to figure out all information so you can settle the matter. Alright, so there are some disadvantages, but hey, nothing is perfect.